Hey there, and welcome to the Divorce Planner Podcast. I'm Alex Beatty. I recently sat down with family law attorney Sharie Reyes Albers of Virginia Family Law Center to get her insider perspective on the divorce process. We covered everything from when you should actually talk to an attorney to the 3 biggest mistakes that can absolutely wreck your case and why understanding your state's laws matter more than you probably realize. One thing that really struck me, Sharie's advice about those emotional texts and emails you want to send to your soon-to-be ex. Don't send them. They can be used as evidence. Whether you're just starting to question your marriage or if you're already in the thick of a divorce, these insights can save you serious time, money, and heartache. Let's dive in. I am so thrilled to be talking to my guest today, Virginia-based family law attorney, Sharie Reyes Albers. And she might be a familiar face to a lot of you out there. I first came across her, like I do a lot of wonderful people in this niche, which is on social media. And I find that your content, quite frankly, is among some of the best when it comes to talking through family law. Specifically, you practice in Virginia, but the advice that you give, that you share, the answers that you're always kind of posting on your page are helpful no matter what state you're in. As always, my guest today and we're not sharing legal advice. We're having a general conversation. So if you have a very pressing issue, a question about a separation or a divorce, please drop it in. We will answer it. But for specific advice pertaining to your state, always check with a local family law attorney. And with that, I just want to say welcome. It's so nice to have you.
Thank you for having me. I'm so excited to be on here with you.
Me too. And I know how busy you are, so I'm just going to kind of jump in. Look, there are so many critical points when you're navigating a separation or a divorce, even in the earliest part of the process where perhaps you and your spouse are just starting to talk about it, or maybe you've been going through a rough patch and you're not sure which way your relationship's going to go. One of the most important things that you can do is kind of start to educate yourself early in the process. And I think you're the perfect person to ask this question, which is, when is really the best time to start meeting with family law attorneys if you're even just considering a divorce?
I think as soon as you start considering a divorce, you have questions about where your relationship is going, do schedule that consultation with a lawyer. Because even though you might not go down that path, family law is not always an intuitive law. Like you might think it's going to go one way, or you think your rights may be impacted another way. So at least you can get some information. All right, these are my rights. How do I start planning if it goes down that path? And if you never need us, great. But it's always good to actually start from the beginning, get that consultation immediately.
You are speaking my language. I'm all about early preparation, as you know. And for anybody who's in need, I actually have a freebie 24 questions to ask a divorce attorney or a mediator. It's just a jumping off point to get you thinking about how to make the most of your time. I don't know about you, Sharie, but there are some attorneys who do offer free consultations. It could be 5 minutes, it could be 15, it could be no free. So you want to make the most of your time before sitting down with them. And to that, I have a broad freebie that gets people to start thinking about what they want to ask. As a divorce attorney, in your opinion and in your experience, what should people be asking when they make those consultations?
Well, really, one big issue is because an attorney is a big investment. Ask them, okay, what's the cost here? How much will you be charging? How do you bill? What do you bill? Also, things like, accessibility. You need to be able to have access to your attorney because in family law, you never know if something's going to pop up. So you want to make sure it's someone who's accessible, fair. And you also, it may not be a question to ask, but also, are they listening to you? And then after you've said, this is the background, this is going on, pay attention to the questions that attorney you're interviewing is asking you, because that'll tune you in of whether they're truly paying attention to you or if they're just, you're walking in, you're just another family law case. Okay, easy. But family law is not like that. It's very specific to each family because each family is unique.
Yeah. I like what you're saying also about, use it as an opportunity to really, it's not just them sussing you out. You're really sussing out, are they going to be the right fit? Ultimately, you want somebody who, as you touched on, you understand their communication style. It's very upfront about what certain costs are. Obviously, there's no magic, crystal ball at the beginning of the process that's going to give you, generate a number that you can set your budget to. You should be prepared. Quite frankly, you should have a bit of a budget set aside to cover the cost of your divorce. The average cost of an amicable divorce in this country is between $15,000 and $20,000. That's you both lawyer up, potentially you're going to court. Mediation can be a less expensive option, but you nailed it on the head. You're making a huge investment in somebody. So it's like, are they going to be a good fit for you? You also want to make sure that you have somebody that you can, I always like to say, you can feel neurotic with. And that doesn't mean come in and lay on the couch and start talking about your problems. That's for a therapist, that's somebody else, but somebody that you can say, here are my fears, here are my priorities, who's going to work with you.
It's very important they express their goal. What would you like? Because then I can talk to them about, well, this is what you need to show. And also the expectations of maybe that we can't get your absolute goal, but this is the more realistic.
But I love that you said that because I think one of the most important things you can do, in addition to organizing all of your paperwork and understanding your money, is really to have your priorities and your goals clearly outlined before you start the process because it acts as a North Star. So everything that you're doing within your divorce negotiations and the process itself should always like draw a straight line to what those goals are. I love that you brought that up. I do think it's important. And quite frankly, to anybody who's listening or watching out there, that's what you want to hear from somebody that you're potentially going to hire. They're not talking about we're going to get them or you've been wronged. It's what are your goals? Here's what's realistic. Otherwise, if you're hearing somebody who's telling you everything you want to hear, I just hear a cash register.
We'll be back after a quick break. Feeling overwhelmed about the possibility of a divorce and not sure where to start? Book a free 15-minute strategy call with me. During our time, we'll talk about where you are in the process and what next steps could be. To schedule your call and learn more about my coaching program, head over to www.thedivorceplanner.net/coaching. Let's get back to today's episode.
So, getting to that, if a couple is going to be going through a divorce and they've been married for a bit of time and they don't have a prenup or a postnup, how can they figure out so that they're doing a little advanced work and so they can figure out what their goals are and what their realities are? How can they figure out what is kind of required of them to split up?
So that would really depend on the state you're in. So where I am in Virginia, we divide things called equitably. Okay, fair. And the time period that's important for us is from your date of marriage to the date of separation. So whenever, this is Virginia. So whenever you form the intent to no longer be married and you live separate apart, can be the same house. That is the sweet spot that we're looking at. No matter how things are titled, we consider that marital property. So you can presume to split it 50-50. Now, there are factors that play in there like fault, because we're one of the states that have fault-based divorce like adultery. So we're a little bit different. So it really is important to figure out your state, what's important to look at there, because I swear like each state's a little bit different. But if you don't have a premarital agreement or a postnup, you're going to want to look at that sweet spot to say, all right, I might have to split this.
That is, first of all, there are a couple of things that you touched on that I'd love to unpack a little more.
Yeah.
I know we've gotten a couple of comments and questions. Please know that I'm going to absolutely get to them, but I want to circle back to two things. First of all, the fact that you are in a fault state, right? This is actually a hot button topic right now in terms of divorce in this country. And there are no fault states like where I live in California. Virginia is a fault state. What are the biggest differences between the two? Because I know it's a big topic of conversation of there should be no fault states anymore.
Well, so no fault is usually what we consider like, for us in Virginia, like you can't use a grounds, right? You're just saying we're irreconcilable differences. We no longer get along.
Yeah.
So Virginia is different. Like if someone commits adultery, you can immediately go to the courthouse and go file for divorce.
Wow.
And that weighs into things like custody, how property is going to be split up. And it weighs into spousal support. So we're an alimony spousal support too, where it's a big ticket item. So Virginia could be separated for a year before you can file if you're doing the no fault, right? Otherwise, the fault base allows you immediate access to the court. So it allows you to do that and does play into how things are going to be split up and support.
That's incredibly helpful. Thank you for going through that in detail. As I said, I know it is quite frankly a hot button topic right now in terms of what states have what laws. Please educate yourself in advance of your split. You can do a quick Google search. I actually just put up a blog post this week, the top 10 most Googled questions about divorce and their answers. And that is one of them. Like, what are the laws in your state? You don't have to go to law school and get a degree and get yourself a divorce. You just need to have a general understanding just to start building your frame of reference and understanding so that you can then plan accordingly. And then you're not kind of knocked sideways by some news that you didn't expect. I'm actually going to jump in. What are your top tips when divorcing someone who is financially abusive when you don't have access to many of the documents you need? That's a good question.
So that one, I don't know if you could resolve that one amicably from the get-go to get financial information. So we have a process called discovery, but you have to file for divorce to get access to that. It's things like where you ask for information, like where are your bank accounts? Give me 5 years worth of your bank accounts, pay stubs, investments, cryptocurrency. You ask for anything underneath the moon, and they have to provide that. Now, you can still try to resolve amicably. I'm not saying that, but that's the way to get it. Because if they're financially abusive, they're not going to willingly hand it over to you. And there are implications if they don't answer fully in the discovery process. And if there's issues with this question of, well, they're controlling the finances, so I don't have money to file for divorce. At least in Virginia, there's options where you can do, it's called, here you go, guys, a Latin term, pendente lite. It means like while the litigation is pending. In Virginia, you can ask for advance attorney's fees to help put on your case, but she would probably have to file for divorce to get access to that.
That's so helpful. Thank you so much. And I will say, if you're early in the process, I also have a what together worksheet on my website. And at the very least, like, don't freeze in place, right? Write down what you do have access to, get copies of that, and keep a list of what you can't get access to. My advice is always go for the tax returns. First and foremost, that's going to give you a lot of information, right? If you can get access to them, whether they're laying around the house or maybe you have a PDF of them, or perhaps you know who your CPA is who filed taxes. If you don't do it on your own, start there and start playing detective, right? It's never too early just to, and also just don't leave everything up to somebody else to do, because you want to come in and present things to your attorney as well to be proactive, as I mentioned earlier. But it's so good to know that there are those steps legally that once you hand it over, they can take it from there, which is great. And obviously, in more contentious situations, or even in some situations where people are trying to figure out marital standards of living, there can be, other experts that are hired, like a forensic accountant. Those are in kind of more extreme and usually more high wealth scenarios, but it can also apply to things like retirement funds, right? Or, you have a quadro expert who'll come in to talk about pensions that maybe you don't have access to. And all the math seems weird because you know what? It's not designed for us to know what it means. Why we need an expert. But thank you for tackling that one. Okay, so this is like one of my favorite questions to ask because there are so many different responses I get from different family law experts. And it's like the divorce 101, which is, what are the top 3 mistakes you see people making in the divorce process that maybe if we talk about today, we can avoid somebody making them?
Yeah. So I think one of the big ones is what you brought up, not necessarily knowing the finances. So start trying to figure that out, because like it's best if you have some knowledge of what's out there, even if you don't know the exact bank account. But if I know they bank with Bank of America, but at least I can find out. I can issue a subpoena to get that information, but have a general knowledge. So someone who hasn't known any financial, that's one mistake, like not having any information. That's why if you're thinking about getting a divorce, it's good to get the consultation or follow Alex, your tips on your side to start doing some digging under the hood. Another mistake would be this is a very emotional field, very emotional, but don't send those emotional texts or emails. We use that as evidence.
Yeah.
And so you want to try not to do that. That's a big mistake. Don't let your emotions take over, vent to somebody else. Don't send it to your ex. A third would be it's dealing with the custody side. So a big mistake I see coming into it is one parent not allowing the other parent to see the child because they're angry. Like, no, I'm not, you can't see them. That's like the 3 I would say that are common top mistakes to avoid.
Those are great. I'm just going to go back over them. Number one, not really having an understanding of your finances. It is so important to go into, even if you can gather all of your information, crunch the numbers of your life, and bring that into your consultations. It's actually going to help you make the most of that time with somebody because you're going to be able to also ask questions with specificity, right? You're going to come in and say, I don't understand this, or here's what the numbers are. And then that person can give you more of a generalized answer, which again is going to kind of audition them for you, which is great. I love what you were saying about just don't text things that you want coming back to bite you in the ass. That goes for social media as well. Nothing in writing, nothing in voicemail. Just leave it. If you're feeling really frustrated, that is something perfectly suited to dealing with a therapist in a support group. Write a letter, write everything in a letter and seal it up and put it away. Don't mail it. More often than not, when we are reactive and not proactive, that's one of the best ways to shoot yourself in the foot during a divorce. And it's also another surefire way for you to be paying a lot more for the process than is necessary, because all of those little missteps, which are kind of like little tantrums, are going to cost you big time. Because I know this about her. She's not free every hour. And for her to have to go untangle something about a text or an email that was sent is going to cost you way more than could ever be resolved by sending something nasty or negative. And then number three, I get chills talking about this. Look, divorce is adult stuff, right? Kids don't have a choice going through it. Being angry or disappointed is absolutely fine, but you're modeling behavior for children. And this is an ongoing relationship that they have with their parent. Doesn't matter about your relationship with that other person. It matters their relationship, and you're showing them how to behave.
We'll be right back after a quick break. Subscribe to the Divorce Planner's weekly newsletter and get divorce prep tips, financial planning tools, and expert insights delivered discreetly to your inbox. Sign up at www.thedivorceplanner.net. Let's get back to today's episode.
When is it too late in the divorce process to switch lawyers?
Ooh, well, from my personal perspective, I don't like to be retained near the trial because I need to have everything set up. So if you're doubting your attorney, if you don't believe they're listening to you or doing what's best for you, it's better to switch as soon as you get that red flag, because your next attorney needs every opportunity to prepare, whether that's catching up to speed of where you are, because deadlines are key. At least in Virginia, we have hard deadlines that if you miss it, your case could be messed up. And you don't want to bring your new attorney a mess, and your new attorney would need time to catch up. So I'd say the latest, at least like 4 months before your trial date, your final trial date, because we have important deadlines 90 days before your trial. So I'd say at least then, but the sooner, the better. If you have a bad feeling, switch.
I really appreciate you kind of laying out more of the structure of the administrative side. So 90 days would be kind of like the max endpoint, because I do know if you are going to switch attorneys, obviously there's a piece of paperwork that's filed, right, with an attorney change. So it is a domino effect. Look, if you're in an extreme situation and you're getting really close and it's not a great situation, yes, push pause, see if you can change dates on things and make a switch. But otherwise, yes, be more thoughtful and listen to your intuition. If something isn't feeling right earlier in the process, don't let it get too far down the line. If you don't feel like it's the right fit, or if you can't even communicate with the person that you have retained, or you're not on the same page. So thank you for walking us through that. Okay, there's something that is another hot button topic that is brought up a lot. Of course, you and I are very much on social media. And so we get this a lot, which is this study that came out that cites that around 80% of divorces are actually initiated by women in the United States. And it becomes like, women are just like looking to start the process and they want to get divorced. But in your experience, what do you find is the reason for that? And do you see more women taking the first initiative and starting the process?
Yeah. So I think it's because, and this is just from my observation of my clients, I would say most women are the ones who are proactive about filing. And I think it's because women, no offense to men, but I think women in relationships tend to be like, okay, I've met my breaking point. I've tried. I'm done. This is kind of the process of saying, okay, I'm going to put this behind me. So once they kind of make that decision, it's not very common to go back, at least with women, is what I've noticed.
Yeah. You know what? I tend to agree. Just as a female myself, it's like once we get to that point, there's usually not a return because we've given it all. And by the way, it kind of doesn't matter who files first either. It's neither here nor there. If you're in a relationship where somebody has decided that they no longer are invested in the marriage, there's nothing you can really do about that, you know? It's not like you can turn that boat around because you've probably been trying to do that. And I like citing this statistic that I actually got from Hello Divorce years ago, which that in long-term marriages, there was a study that said there's usually a few years before they get to the point where they decide to file for divorce that they're trying to figure out, can we save it? What's going to happen? So it's like you've already exhausted the whole process by the time you get there. It's not the first step. It's usually filing is the last step. Are you able to request a new GAL?
Yeah, it means guardian ad litem, which is an attorney that's appointed for the child. That's usually in custody and visitation cases. It's hard. It can be done. You can put on a motion to say, ask the court. You have to ask the court permission to replace this guardian ad litem. But it's not easy. You have to be able to detail why you think this guardian ad litem is not representing in Virginia. It's the best interest of the child, because that's what they should be focusing on, is what's best for the child. If you don't think they're doing that, before you file your motion, collect your evidence to say, this is why I want this person removed. But it can be done.
That's great. Thank you so much for tackling it. And I love what you said about that. Gather your evidence. And to that, I'm going to wrap it up with this question. What's the best way people can prepare themselves before coming to you, right? Like, what's your ideal scenario of somebody engaging you? How are they best prepared to start that process so that you can hit the ground running?
Yes. And I think through the videos of getting a lot of more educated clients, it's good. The social media is good. It's teaching. Knowing, like I said, this field of law is emotional. So try to gather your thoughts. Put like a timeline together. This has happened. This has happened. This is where we are. And then also, if you have documents, try to bring in, because people come for modifications. Like, can I modify custody? Bring the orders. If there are, have at least like on a piece of paper where the finances are, what they are, a general knowledge. So for Virginia, like I said, it's key of knowing dates. Like if I say I bought my house before I was married, that's key information for me in Virginia. So try to know generally that kind of information when you bought things, but just like a general outline, because then you're able to bring that to your attorney. They can understand better and help provide you better advice in that initial consultation.
Yeah, it's my jam. I was basically setting you up there. I'm all about preparing people before a divorce, because by the way, even if you're at a point where you're not sure if your marriage is, going to continue or if you're going to end in divorce, if you do some of this proactive work, if you move forward with a divorce, you're better prepared to start the process and be your own best advocate with your eyes wide open moving forward, which is what you want. Nobody's going to care about the details of your life like you are, right? Your attorney only knows so much about you and your experience in your life. You have to fill in the blanks, really. So don't be silent. If you have a question, speak up. If you think something is not being covered, you have to cover it. And you have to be your own best detective, number one. And then number two, I want to quickly jump to one last question. If you have to, oh, and by the way, and if for some reason you decide to reconcile, you have all of your meaningful information in one place and you have a clear understanding of your financial realities, and that benefits you either way. It's a win-win, really. It's never a waste of your time to invest in gathering all of your necessary statements and accounts and documents and finances and setting goals. Even if you're not going through a divorce, it just benefits you overall. And okay, with this, I promise I'm going to wrap it up, but we got a lot of action today. Are there restraining orders against changing a revocable trust once divorce is filed?
There are, so you could ask for, at least in Virginia, we do that lovely Latin term that I told in the beginning, the pendente lite. So while the matter is pending motion, we ask for injunctions then. So you can request from the court to enter an order so that you can preserve, we call it preserving the marital estate, to prevent them from getting rid of assets, depleting assets, minimizing them. So it can be done. And really, the sooner you do it, the better.
Well, Sharie, this has been phenomenal. Thank you so much for spending this time with us today, for tackling not just my questions, but all of these follower questions. All the things we discussed today are general information. This is not legal advice, but hopefully what it does is it ignites in you the knowledge that education is going to get you the best results that you want, and not to be afraid of the process, just to educate yourself. And there are accounts like mine and hers that can really help make that process a lot easier. So, with that, I just say thank you so much. And I hope to talk to you again. I'd love to have you back next year.
That's a wrap on today's episode. I hope you found it helpful. For more free resources, check out my blog at www.thedivorceplanner.net/blog. You'll find articles on how to emotionally and financially prepare for divorce, gain insights into the process from divorce experts, and empower yourself with tips and tools that make your divorce journey easier. And you can follow me on Instagram at the.divorce.planner, on Facebook at Divorce Prep, and on YouTube at The Divorce Planner for daily divorce prep tips and support. I've helped hundreds of clients and thousands more with my digital divorce prep tools prepare for divorce, and I'd be honored to support you too. I'm Alex Beatty, and this has been the Divorce Planner Podcast. Until next time, remember, divorce is hard. Preparing for one doesn't have to be.